I'm sorry, y'all. I got disconnected. I am so sorry. But happy Friday night. How are you guys doing? Happy Friday night. I'm talking about Monday night. I'm so tired. I am so tired, and I am talking about Monday night. I'm going to put my TikTok up too, guys. I'm going to go live on both. Everybody, welcome. How is everybody doing? I know, I'm thinking it's Friday. I'm so sorry. I have lost it. Okay, guys. So I am going to be able to go to court tomorrow. Initially, I did not think I was going to be able to go, but it looks like I'm going to be able to go. And hi, I'm going live on two things. Um, but I thought we could talk about some motions as we prepare for tomorrow. And, I was sitting just going through some things, going through my emails, and I noticed that some motions have been filed even as late as today. And so I am going to share those motions with you guys. We're going to look at this one. I think this one is very interesting. So, can you guys see this? So, this is a renewed motion for Brady evidence to be provided. And Attorney Steele filed this motion. And I thought that it was important to review this motion because I think that Attorney Steele believes that there are still some things missing from that transcript. So we can just kind of go through this. Hold on, let's see. So pretty much it's just the same thing that everybody knows. Mr. Jeffrey Williams, and hereby files this renewed motion for all Brady evidence to be provided. Let's see. So he just pretty much is using the same case law he used in the first motion for Brady evidence, which is Brady v. Maryland. And this is a very short motion. It's only 3 pages, but guys on TikTok, we're talking about this renewed motion for Brady evidence that Attorney Steele filed. So pretty much this is the main part that has my antennas, and it says paragraph 5, it has been proven that lawyer Love and or lawyer Hilton have not provided Brady evidence and have fact attempted to hide same from undersigned counsel. And then he references the ex parte transcript dated June 10th, 2024. So, what do you guys think about this? I'm not too sure what Brady evidence he's talking about because, like I said, I'm not an attorney on the actual case, so I don't get the actual privilege to see what has been turned over and what has not been turned over as far as discovery goes. But I am really curious to see what Attorney Steele believes has not been turned over. I imagine that he believes that there is something missing from the transcript, or that maybe even he's waiting on the state to tell him what they heard or what they believe would have been Brady evidence in good faith. Maybe he's just waiting for a conversation with them. This motion leads me to believe that he may not have even had a conversation pertaining to what happened in the ex parte meeting with the state. But it is very interesting that he's saying that they are attempting to even hide the information. So let's get the lights up. Um, so tomorrow, another thing I was wondering is exactly how many motions are going to be heard. There have been so many motions filed. I think it would be impossible to hear all of the motions, but I would hope that number one, this motion would be heard. And let's look at this. Let's remove this and add this. Some of you guys may have already saw this, but this is the renewed motion for bond and brief in support of a pre-verdict bond, and this is for Young Thug as well. And we can just go through this. Once again, it is for Jeffrey Williams through Brian Steele. And a renewed motion is just pretty much exactly what it states, renewed. So it's either been withdrawn by the party that filed it or the judge has ruled on it. But in motions, specifically bond motions, they can be brought back. Usually, when a bond motion is brought back, there has to be a change in circumstance. And arguably, we would believe that a change in circumstance has definitely occurred in this situation. And I would say a change in circumstance has occurred because we have been on break for weeks. The judge has been recused. There has been an extreme delay in this speedy trial. And to me, as a defense attorney, I would definitely say that that is a change in circumstance. It's not your everyday, keep going, normal trial. This is something that is unprecedented. And I believe that they are now entitled to a bond. Like I said, I believe from the beginning that they have been entitled to a bond. And before I go into this, I'll just start with this again. Normally in Fulton County and most counties, but specifically since we're talking about the YSL case, normally when someone goes to jail, they go to jail unindicted. And when they go to jail unindicted, they then have the opportunity to have a first appearance. And when they have this first appearance, they go before a magistrate judge. And there's a difference between a magistrate judge and a superior court judge. So, a magistrate judge has designated powers that superior court judges designate to magistrate judges. So, magistrates handle things such as bonds, um, preliminary or hearings or probable cause hearings. They can handle matters such as evictions, small claims, things of that nature. You'll never see a magistrate judge handling a plea or handling anything past what when a case has been indicted. So generally, when people go to jail, they are arrested, they are unindicted, and they go to this first appearance judge. Once they get to this first appearance judge, based off of the IOLA factors that we know in Georgia, um, is how it's determined if they'll be granted a bond and what that bond amount looks like and what are the conditions of that bond. So the first condition is going to be the criminal history. Then we're going to have likelihood of reoffending. We're going to have, is there a possibility of witness intimidation? Do you have community ties? And are you going to come back to court? So here specifically, we're talking about Young Thug, and I would say that from day one, had he would been before a magistrate judge, he would have been eligible for a bond. He has no previous felony convictions. He has clear community ties. He's paid millions of dollars to retain a lawyer. And, even when I'm in court and I have a client who gives me their last $5,000, $5,000 is $1 million to some people, And I argue, Judge, this shows that they take their case serious, that they're going to come back to court, and this is an investment. So consider that when considering bond factors. Also, we have heard the state over and over and over again say that they have the ability to intimidate witnesses. Me personally, I have seen no evidence. I've heard no occasion where a witness was actually intimidated. So I think that he meets that factor as well. And there's no likelihood of reoffend. I mean, he has no FTAs, anything that indicates that he's not going to come back, he's going to commit more crimes, anything. So, unfortunately, when these guys were arrested, I believe it was on May 9th, 2022, if I'm correct. When these guys were arrested, they came to jail. Thank you so much for this super chat. Thank you so much. They came to jail indicted, which means they automatically had to go to Judge Glanville. They never had the opportunity to go to a magistrate and actually have a fair chance at getting a bond. So their first bond hearing was with Judge Glanville, and we see how that has gone with Judge Glanville. And not to get completely off topic, but like I said, I was on the YFN trial, and my client got a bond immediately. He got a bond. Well, he got a bond at his first opportunity to get a bond. He came to jail. I believe he was indicted when he came to jail, but everybody didn't come to jail indicted. But they went out of their way to get these guys indicted and get them in custody and keep them in custody for whatever reason. And then we saw all of the attorneys constantly filing these bond motions, filing these bond motions, filing these bond motions, and they were denied one after another. And I think eventually one person got a bond, and it was like 500,000. And then I know people started taking pleas left and right. Needless to say, we're here at a renewed motion for bond. And right here, I guess you guys can see on the first page is that, still alleges that for pretrial bond analysis, the presumption of innocent remains with the person of the accused offense, even a capital offense. So, like we know, you are supposed to be presumed innocent until proven guilty. But here, when I was on Mr. Jeff's show, he said this, and it was the first time it really resonated with me. These guys have been guilty from the beginning, trying to prove their innocence. They have never had the true presumption of innocence as required by law. Um, Courts view the criminality of the accused to be innocent of the charges waged against him or her. It has been written that the most fundamental premise of our criminal justice system is that criminally accused cannot be punished for an offense until the prosecution proves guilt beyond a reasonable doubt. So, once again, just goes back to people have rights from the beginning. These guys had a right to a bond. And there are other people on this case, and I'm just specifically speaking about Jeffrey Williams because this is the bond motion I have in front of me. But there are other people who should have been entitled to a bond. But there are some people who I understand on this case why they were denied bond, but they are not similarly situated. They have several felony convictions. They're charged with things. And then also we got to understand Thug's only charged with, I think, the RICO count. We have people on here charged with murders, charged with all kind of things. And not that they have any less rights, but when considering these bond factors, it's completely unfair to hold someone with no felony history charged with one count on the indictment to the same standard as someone with 3 and 4 felony convictions, 20 felony arrests, and FTAs. It's just not fair. Okay. All right. And so this is pretty much still arguing the standard of innocent until proven guilty. And then here we go. Our highest court explained in a bond hearing, Mr. Williams bears the initial burden of producing evidence that he would. And here are these factors that I just talked to you guys about. Not pose a significant risk to flee the jurisdiction and will return to court when required. This is when I talk to you guys about. I mean, if you paid someone millions of dollars to come and defend you, I am pretty sure. And then, I mean, where is that gonna go? Like, where is he gonna go? Like, where is he gonna go? Okay. Two, not to be a significant threat or danger to the community or to any persons or property. Once again, I say, I mean, he has the burden, but what has he done? Where's the evidence that he will make threats? Where's the evidence of his violent behavior? Okay. Not to be a significant risk. I'm sorry, not be a significant risk to commit a felony while on bond. No felony history, no indication that an additional felony would be committed. Looks like he meets this prong to me too. And not be a significant risk to intimidate witnesses or otherwise obstruct the administration of justice. Once again, we have heard no evidence, no instances, or anything that would say that he would intimidate a witness. Now, we've heard the state say over and over and over again that, you know, this is their fear, but where does this fear come from? Okay, so now in this motion, he is breaking down the things we just talked about. So he says Mr. Williams is not a flight risk. To meet this burden, Mr. Williams must first present evidence showing his roots in the community, which would include the length and character of residence in the community, employment status, and history of responding to the legal process. So, right here, Brian is just going to pretty much outline his community ties, why he's not a flight risk. And he says that he was born and raised in Jonesboro, south of Atlanta. Since born in 1991, has maintained his residence in Atlanta. Although he has traveled the globe and performed his music and artistry in every continent, he always returns to his home in Atlanta, Georgia. In fact, days before the return of the original indictment and arrest of Mr. Williams had returned to his Atlanta, Georgia home from the country of Norway. Mr. Williams is one of 11 children, and he is the father of 6 children, and lists their ages. All of Mr. Williams' family lives in Atlanta, Georgia, including his parents. There is not many among us who has stronger roots in our community other than Mr. Williams. So I would say that that is a strong argument of community ties. Not many people are going to leave 10 brothers and sisters and 6 children and their parents to flee in the middle of a trial. I just doesn't make sense. Okay. Um, Mr. Williams, and then now I'm going to skip through this, but pretty much Mr. Williams is, well, this just talks about his employment, and he was paid $1 million, gainfully employed through his artistry, just more tying him to the Atlanta community. Mr. Williams has appeared in the court in the past, previously represented by undersigned counsel Brian Steele for approximately a decade. So this speaks to Brian and Thug's relationship. I think they have a great relationship, and it speaks to Brian's ability to keep his record clean. You know, everybody doesn't come from the same background in the same situation. So a lot of times, especially as a criminal defense attorney, I see people and they're so young and they have these criminal histories that are lengthy, or these multiple arrests that are lengthy. And it's just really because we don't always get to choose the cards we're dealt in life. And people do what they know. But as we see, I mean, there is no recent arrest. You know, he's been doing pretty well. I can't speak to what has happened in his young adult life, but he has a great lawyer. He's maintained a relationship with the lawyer, and Look, Mr. Williams' entire adult life, Mr. Williams has never missed nor been late for a court appearance. Mr. Williams has a history of responding to the legal process. Undersigned counsel is in possession of Mr. Williams' passport and has permission to surrender this passport by the honorable court for purposes of bond. I mean, he's even willing to give up his passport. These are all things that show, look, I'm gonna come back to court. So we get it. He meets this prong. He's gonna come back to court. Um, he also says right here, Brian says that he intends to present witnesses to testify at the renewed bond hearing, specifically Mr. Williams' parents, managers, members of his record label, childhood friends, business associates. So we saw this at the beginning. This is kind of, I saw some of the beginning. Like I told you guys, I didn't watch all the way through, but I did kind of watch the beginning, and I did see these bond motions, and I saw people coming and supporting different the different defendants. And so I saw people talking about the community events he had and talking about how he was a leader at his record label, a leader in his community, and things like that. Just looking, you have to remember to dumb down the law. Okay, FTA, sorry about that, guys. So FTA is a failure to appear. So that's something that we consider when looking at bonds, is whether someone has missed the court date or had a warrant for missing court. So that is FTA, failure to appear. Thank you so much. Okay. Mr. Williams, prong number 2. Mr. Williams is not a significant threat to the community or to any person or property in the community. So, Mr. Williams has taken the initiative to secure the commitment of full-time, off-duty sworn law enforcement officers to watch his home and secure him in his home for 24/7 house arrest. Okay, so we got that on here. Miss Radford, she said that on TikTok. So basically, he has even said, hey, look, I'm even gonna put up more resources to have 2 officers sit in my house, make sure I don't leave, monitor what's going on, see who's coming, see who's going, and be on house arrest for 24/7. Other than to come to court. I okay. Mr. Williams is also willing to wear an ankle monitor. Mr. Williams would also be willing to submit to a condition that any person who would visit him would have to be on a approved list provided by this honorable court, as well as the district attorney's office. So he's saying that he's willing to have the DA's office screen people coming to visit him and be on an approved list, and not just approved by the court, but approved by the district attorney's office. I think that okay, moving on. Moreover, any visitor will have to consent to being searched physically and electronically by the off-duty sworn police officer. And if the visitor does not agree to consent to the search, the person will be prohibited from visiting Mr. Williams. Mr. Williams also agrees that any of his text messages, telephone calls, emails, or other forms of communication in any manner can be secured, and that information provided to this court if desired. Okay, so he is willing to give up his Fourth Amendment rights. I mean, he has the right to privacy, and we have to be, there has to be certain reasons why our persons and papers can be searched. And he is not convicted, and he is innocent. And he is already saying, hey, I will give up that right to show you how serious I am about coming to court, abiding by the law, and keep going. Mr. Williams was in custody on a recorded line. The cost of this 24-hour, 7-day-a-week detailed police, as well as the cost of the ankle monitor. Any related costs would be incurred by Mr. Williams. With all of these parameters in place, there's no way that Mr. Williams could be a threat or danger to the community or its property anyway. Okay, moving on. I just can't believe this. And these were some of the initial conditions that Attorney Steele presented. It's not like, oh, he didn't ask Glanville this the first time. These were some of the initial conditions that were presented. And it's crazy because even if it was no the first time, after it took 10 months to pick a jury. I mean, when is enough? When do you say, hey, let me let him do this. Let me give him a chance. And if any of the conditions are violated at any point, a judge always has the power to revoke the bond and bring him back in. But I don't know how. I mean, how would he go anywhere? The above conditions place Mr. Williams essentially in custody in his home. Specifically, our General Assembly has provided for the creation of electronic pre-verdict release to assist sheriffs in alleviating jail overcrowding by creating alternative methods of pretrial release, monitoring, and home confinement. The legislator found that electronic release, monitoring, and home confinement incorporates modern technology to accomplish various purposes. Therefore, our General Assembly explicitly recognizes that Mr. Williams' home is a place where he can be confined and restricted in movement for the purposes of electronic pre-verdict release on bond. So, I'm gonna just talk about this. So a lot of you guys hear about the Fulton County Jail, or what we call Rice Street. Rice Street is a difficult place. I can probably count on my hands out of I probably have about 80 clients right now. And well, I'll say probably about out of the 80, maybe like 30 in custody. And I can probably count on my hands out of those people who have not been stabbed in that jail. I I'm gonna say it again. I can count on probably one hand the amount of my clients who have been in a extended period of incarceration and have not been stabbed. That jail is a terrible place. The conditions are terrible. You guys have saw the young man who was eaten alive by bed bugs. He was there on a misdemeanor charge. The jail is so overcrowded that a lot of people are outsourced to the other Metro Atlanta um, facilities like Cobb County, and that's where Thug is. And then we have Union City, which is like a smaller annex. We have ACDC, which is like a pretrial jail. Alpharetta. So sometimes I go to Fulton County and I can't even find my clients because it's so crowded that they are outsourced to these other counties, and it's hard to get to them. So pretty, I guess, maybe around the pandemic or shortly after, there we a lot of people were getting bonds, and they were getting these bonds with the condition that they have an ankle monitor, because the jails were just overcrowded. They were way too crowded. So here, Attorney Steele puts in the legislation that supports allowing Mr. Williams to be subject to confinement in his home, and he puts the case law to support it. Okay. um since May 9th, 2022, Mr. Williams endures the torturous conditions in the county jail. 22 out of 24 days locked in a small cement cell with no contact with another human being except when his counsel visits and in court proceedings. Inedible food, living in a squalor ant infested room, and unable to see any activity, movement out of the cell's window. I get it, guys. Jail is jail. I 100% get it. And I tell my clients all the time, look, you are in jail. Okay. It's not a, I don't know, it's not a luxury hotel. Unfortunately, you are in jail. However, I've never had a situation where a speedy trial was filed and my client was still in jail 18 months later. This is a different set of circumstances. Now, I have had clients that are in custody for years without indictment, even though these guys went to jail indicted. That's what eats me up the most, because high profile, celebrity, whatever, it's whatever, everybody has equal rights. And there's no reason why I should have clients who are sitting in the Fulton County jail 2 years without indictment. And then another big problem in these jails are these jail fights. And how can you keep someone in custody for 2 years, indicted or unindicted, and think there will be 3 years? There are people who have been in Fulton County. I take pleas sometimes for people who have been in Fulton County 4 years and think that there will be no incidents. Anyway, but I just can't imagine. And that's another thing. He's in a different posture. And I mean, he can't be in general population. So it's like because he is who he is, then he has to be subject to 23/7 or 22/7. I'm sorry, 22 hours in a cell. That's why I thought it was super cool. Side note, I thought it was super cool when Brian said, "Hey, if you're gonna put me in jail, that's fine. Just can I be cellmates with my client?" Okay, moving on. Sorry. Prong number 3. Mr. Williams is not a significant risk to commit a felony while out on bond. Let's see. Okay. Hold on, guys. I'll be right back. On TikTok, I have to get back with you. My phone's going to die. So, third prong, Williams is not a convicted felon. This fact alone satisfies the bond factor. Moreover, law enforcement officers executed a search warrant on or about Monday, May 9th, after the arrest of Mr. Williams on the grand jury indictment. And so the grand jury indictment, pretty much that just means that, like I said, he was indicted straight from the grand jury. They are like the people that come together and based off of warrants and officer testimony determines whether or not that you'll be indicted. And so that's what happened. Indicted immediately. Court is at 8:45 a.m. Court is at 8:45. Okay, while the search led to discovering drugs and guns located in the home, but at the same time, this search there were numerous people in and at the house. Mr. Williams has several homes in the Atlanta area. Thus, Mr. Williams is not a significant risk to commit a felony while out on bond, especially with the use of the security and other conditions offered before. Okay, next. Mr. Williams is not a significant risk to intimidate witnesses or otherwise obstruct the administration of justice. Mr. Williams has suggested as a condition of his bond that all of his calls, texts, and messages and other communications be monitored. So this is pretty much what we talked about before. He's saying that this will prevent him from the possibility of intimidating any witnesses in today's times. Hold on one second. Okay, sorry, y'all. Williams. So this pretty much just goes back to that he's not going to intimidate witnesses. We've heard over and over and over and over and over and over again that the reason he should not be let out is that he is scary. He has money, this and that. You know, I'm gonna say this. It really grinds my gears that they say that, yet Trump was able to walk into the Fulton County Jail with a bond and walk right back out. I don't understand the difference between. I don't understand the difference. I don't know. Maybe you guys can help me out with that because that is exactly what happened. Okay. And this is just a summary, that based off the information above, Mr. Williams must be granted a reasonable bond with the conditions the same. Okay, guys. So I just went over that. I also want to go over one more. I want to go over one more that I'm going to pull up, which is I want to look up the difference between Bruce Harvey's mistrial and motion for a mistrial, and Cat calls him YSL ponytail. But between Bruce Harvey's and Doug's, because I think that is very, very, very important for you guys to kind of understand what's going on. So let me pull these up for you. But in the meantime, let me see. Yeah, the difference. I understand the difference between Trump and Thug theoretically, but I'm just saying, as far as they're both rich, they both have the power to intimidate witnesses. And guess who's a felon? Guess who's a felon? Let me see. Let me see if I can get some of these mistrial motions up. Well, let's see. I don't have this one up, but let's look at some of the states motions. Let's see what they have for us. Okay, got that one. I'm gonna get a few different ones pulled up for y'all. Let's get the likes up on TikTok. Okay, I'm gonna present this one. Yeah. Okay, let's get this one. All right, I'm gonna share this one. Okay. Okay, so now we have a motion from the state. So this motion is the state's response in opposition to defendant Nichols' motion for mistrial and severance. So the state of Georgia hereby moves this honorable court to deny defendant Nichols' motions for mistrial in response and opposition. How do I get this? Hold on, guys. Let me get this off. Hey, Kat, how you doing? Okay, so a mid-trial substitution of judge does not violate the Sixth or 14th Amendment rights to a trial by jury. So we can assume here, like I said, I can't go through every motion tonight. So we're going to just pick and choose some. But we can assume here that Attorney Harvey, his first paragraph was that a mid-trial substitution was a violation. So, in paragraph 1, defendant Nichols asserts that the mid-trial substitution of the trial judge violates his Sixth and Fourth Amendment rights. The mid-trial substitution of a judge does not violate the Sixth Amendment or 14th Amendment rights. The claim was made that in McIntyre v. State, and the Supreme Court of Georgia assumed for purposes of this appeal only that these rights are implicated by the mid-trial substitution of judges and untimely rejected that claim. However, when it did so, the court specifically referenced People v. Espinoza, and the Supreme Court of California held that mid-trial substitution of those judges does not violate these rights. Okay, I'm just going to say I don't know what that means. It sounds like, let me just go back. How do I unpin this comment? Can somebody tell me how to unpin the comment? Let's do one. Okay, there we go. So it's out of my face. So I'm going to read this again because maybe I didn't understand it. In paragraph 1, defendant Nichols asserts the mid-trial substitution of the trial judge violates his Sixth and 14th Amendment rights. The mid-trial substitution of a judge does not violate the Sixth Amendment or 14th Amendment rights. Oops. The claim was made in McIntyre v. State, and the Supreme Court of Georgia assumed for purposes of this appeal only that these rights are implicated by the mid-trial substitution of judges and untimely rejected that and ultimately rejected that claim. However, when it did so, the court specifically referenced People v. Espinoza, in which the Supreme Court of California held that a mid-trial substitution of judges does not violate those rights. I think that I don't know. Maybe in oral arguments they can explain, because to me that was just repetitive. It seems like three sentences written over and over. It doesn't really give any facts, or it doesn't allege why it's not a violation. Anyway, next page. Concerns with directed verdict motions are unfounded. In paragraph 2, defendant Nichols asserts the mid-trial substitution is inappropriate because he claims it will affect his ability to request a directed verdict at the conclusion of the state's case in chief. This concern is unfounded. A directed verdict of acquittal is only available if the evidence is insufficient as a matter of law. To overcome a motion for directed verdict, the state would direct the court's attention to admitted evidence which establishes the elements of guilt. Okay, so a directed verdict is just pretty much, how you all you guys keep saying, um the state hasn't proven YSL is a gang. The state hasn't proven RICO. The state hasn't proven. So pretty much, if the defense or if a defendant believes that the state has failed to present evidence to prove its case in chief, they can ask for a directed verdict at the end of the case, at the end of the state presenting its case. And here, Attorney Harvey argues that because the mid-trial substitution is inappropriate, because it will interfere with that right. I'm not too sure. Yeah. Yes, that's Jason. That's all I could do. I couldn't figure it out. So, guys, I had to just make a smaller one because it was so big. And it's not tapping. I think it's because I'm in StreamYard. Anyways, issues with familiarity. Paragraphs 3, 4, and 6, defendant Nichols asserts the court advised the parties that she was unfamiliar with the previous trial proceedings and that this would affect the court's ability to rule on motions and objections. In paragraph 5, defendant Nichols asserts the court's level of familiarity violates his due process rights. Defendant Nichols' claims turn upon this court's familiarity with the case. Among those jurisdictions which have statutes regarding the mid-trial substitution of the trial judge, some require the new judge to certify their familiarity with the record. Okay, so this is my biggest concern, especially with, and Gap Girl, there's more than 5. There's a lot more. But this is exactly what I'm talking about, is how can anything really happen tomorrow? How is, I think we've had a new judge for 2 weeks. Has she really had time? And I'm not saying this about her credibility or anything about her, but has she really had time to become familiar with everything that has happened in the past 18 months? Is she going to be able to rule on every single thing? Like that's the only thing that concerns me. I feel like tomorrow the most important motions are going to be the motions for mistrial and the motions for bond. There are other motions that have been filed, but a lot of you guys who are following the case closely know that Judge Whitaker did put out an order to unseal some of the orders and filings into the case so that she can become more familiar with the case. But I just don't understand how she is going to be able to catch up on everything that's happened in the past 18 months and rule on a lot of these motions tomorrow. So I definitely disagree with C. Let's see what they're using to argue. I guess they're just saying that Georgia does not have a statute. Remember, this is the state's motion responding to Attorney Harvey's motion. Georgia does not have a statute that specifically addresses a mid-trial judge. Georgia's primary case is McIntyre v. State, while one concurring justice opinion that she would have the replacement judge review the prior proceedings and state on the record his or her familiarity therewith as to establish that the replacement judge is fully prepared. I mean, so they're just pretty much saying that Georgia doesn't have a specific case law, or there's no specific case that or statute that addresses a mid-trial replacement, and that they believe that Whitaker's ready to go. I mean, personally, I feel like this is even more of a reason why these guys should at least be given a bond, because it will at least give her time to catch up. And it's not really fair that these guys have to sit in custody while Fulton County figures out who's going to be the judge and what does the judge need to know. Taffy, I've been live since the time I said I was going live. Okay. Let's go to D. The temporary recess of the trial is not a basis for a mistrial. In paragraph 7, defendant Nichols moves for a mistrial given the month-long recess in the proceedings. Defendant Nichols cites no law in support of that claim. Indeed, a month-long recess, though unusual, is not unprecedented. And then they cite case law. And then they go on to the court should, paragraph E, the court should again deny the request for severance. Defendant Nickel again moves for severance based on alleged spillover. This court should deny their motion again. It is well established that where evidence of one crime would be admissible in the trial of the other crime, it cannot be said that the trial court abused its discretion in denying a motion for severance. Here, defendant Nichols and his co-defendants are charged with a violation of the Georgia RICO Act, in which the state alleges they engaged in conspiracy. Defendant Nichols' separate action and those of his co-defendants are alleged in the indictment as overt acts of this conspiracy. So, Adrienne Love submitted this. So basically, she's saying that the month-long recess is not a reason for a mistrial, and that Attorney Harvey states no case law to support that a month-long recess, although unprecedented, is not basis for a mistrial. I mean, but she doesn't cite any case law either. Also, she's saying the motion to sever should be denied because the overt acts, and for you guys, the overt acts are what make up a RICO. So overt acts are the different crimes, the shootings, the robberies, thefts, or whatever, the different acts that make up the RICO. And the RICO is the criminal conspiracy that, where one or more come together to conspire to commit crimes. And then you have the gang statute, and to commit these crimes in furtherance of the gang. I'm reading. Every time I see Cat, I have to read. But anyway, sorry, guys. So she's arguing that it's improper for Nichols to be severed because his crimes or overt acts are what help establish their RICO and their gang counts. I mean, we've had a lot of people severed for a lot of different reasons, and I'm not too sure exactly why Harvey wants to be severed at this point, but I wonder if this will be argued tomorrow as well. So, like I told you guys, yeah, I saw this. Like I told you guys, I will be there tomorrow. And I cannot wait to talk to you guys about what happened. And I know you guys will be watching. Tomorrow is Tuesday. So I'm going to come on a little early as soon as I get out of court, and we will do a recap of what happened in court. And I will see you guys tomorrow. Thank you for hopping on with me today. I appreciate it. And I'm going to try to get some rest so I can get up and be on time at 8:45. All right. Thank you. Thank you guys. See you tomorrow.